Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and we're continuing to learn about shareholder litigation. In this episode, we're going to focus on pleadings standards. These are the rules for how you must write your initial complaint in order to survive early challenges. We're going to build directly on prior discussion of direct and derivative actions, which included the requirement of standing or demand. Pleading standards are like gatekeepers. They ensure a suit is detailed enough to proceed, they prevent fishing expeditions, and they stop cases before they get to the very expensive discovery phase. They tie closely to federal securities rules for direct claims and to Delaware general corporation law or the Model Business Corporations Act for derivative ones. By getting this step right, you address agency costs head on because you force the shareholders to make well-supported allegations that agents, like managers, had somehow deviated from their fiduciary obligations. In any lawsuit, your complaint is like the opening salvo. It's the document that lays out the claims, the facts, and why you deserve relief. But in shareholder litigation, courts demand extra detail because it's possible to have vague or harassing suits that can result in expensive settlement, in part because of that cost of discovery. So for direct actions where a plaintiff is harmed, like through a material misstatement, these are often filed in federal court because we're dealing with federal securities laws. And the standards from cases like Twombly and Iqbal require those complaints to be plausible, not just possible. Plausibility means alleging specific facts that make your story believable, showing the probability of a real violation. Under the Private Securities Litigation Reform Act, which governs many direct fraud claims, you have to plead with particularity. You have to say who made the misleading statement, when it was said, why it was false, and how it caused your loss. This all ties to SEC Rule 10b-5, the main anti-fraud rule, which requires a showing of materiality, asking, would a reasonable investor care? Showing scienter, which means intentionality or potentially recklessness. Showing reliance, that you believed the lie, that the shareholder actually took action on account of the misstatement, and causation, that taking that action led to the shareholder harm. And not just super proximately in some vague sense, but relatively directly. For example, if a company says our product is safe, but they knew of defects, the complaint just can't say they lied. They have to detail when the statement was made, talk about the internal warnings that were ignored, explain the stock purchase, explain the stock drop, explain how the truth caused the stock to drop and not some other factor. Weak pleadings mean early dismissal, which is actually a good thing because it protects companies from fishing expeditions and should ensure only solid claims against misaligned agents proceed. For derivative actions, typically in Delaware under the DGCL, pleading standards are also rigorous, but they're here tailored to fiduciary duties because what we're claiming in these derivative actions is that the agents of the corporation breach their fiduciary duties to the corporation. So again, we're dealing with failures in corporate governance where the shareholders have to step in and cause the corporation to defend itself. This is where the corporation is harmed by its directors and officers. So the first step is pleading demand futility, or you can ask the board to sue, and they may do it, in which case we don't have this issue. But often the suit is against the board. So the first step to get through the pleadings is the demand futility three-part Zuckerberg test we covered previously. And that asks whether there's directors, a majority of directors, that have either a personal benefit, a liability risk, or a lack of independence. DGCL Section 327 says that continuous ownership is part of this. You have to plead that your shares have been owned throughout the cause of the harm in the litigation. So you have to plead that. Delaware Rule 23.1, which parallels Federal Rule Civil Procedure 23, requires detailing why the board can't handle the claim itself. So you'd have to actually specify why there is some kind of self-dealing or prove the Zuckerberg test is met. So if you want to show that directors wasted assets on perks, you have to plead the specific expenses, who approved it, and why it would be futile. Like, for example, the majority of directors benefited from these perks. Courts demand this to respect business judgment while allowing suits that truly address agency costs to proceed. These standards connect directly with the substantive law of direct and derivative claims. So again, we're seeing an alignment between these enactment of our rights through the procedural rules to the actual underlying substantive law. So in direct claims, we're often dealing with Rule 10b-5, like insider trading or material misrepresentation. And we require pleadings with particularity how those violations of Exchange Act laws violated the Exchange Act, causing the personal loss. So if executives sold stock based on inside info, that would be a way to sue under the Exchange Act. And you would have to plead that with particularity in order to make the pleading standards. In derivative actions, the Delaware General Corporate Law has fiduciary provisions that demand duty of care and duty of loyalty. And what we do is we prove breaches of those, like a failure of oversight under Caremark or failure of the duty of loyalty and self-dealing claims that harms the company. Again, the concept of pleadings is they prevent abuse, because once we get to discovery, we're going to discuss how that gets very expensive. This high bar reduces frivolous lawsuits, but some will argue the bar is too high and it doesn't provide enough policing against these type of agent misconducts. So this is an ongoing dispute and debate. And there are new trends like cybersecurity disclosure. So there are new ways that we can have allegations. And it's not totally clear whether a failure to abide by cybersecurity disclosure rules causes direct or derivative harm. So there are some new things that are continuing to shake out. And we're going to see this appear in the pleadings because surely the board of directors will try to dismiss a claim saying that it was filed improperly, like an allegation that a cybersecurity disclosure material misrepresentation is a direct claim might be met with a motion to dismiss saying that's an improper forum. We're still seeing this play out in our early days. But the point of this lesson, as I recap here, is to explain how pleading standards set the bar for a suit's survival. And in the case of shareholder litigation, just like all civil procedure, we have to address the substantive law underlying it. So, a core theme I just keep repeating as we keep learning about shareholder litigation is fundamentally to understand this topic, you have to understand the underlying law, which in the case of direct actions means you have to understand securities regulation, because usually we are suing because the shareholders, as shareholders, were harmed on that basis. And there could also be shareholder contracts where the shareholders are entitled to information rights or voting rights, and they're harmed as a result of that. On the other hand, in derivative litigation, the pleadings have to show with particularity that the demand requirement has either been met or would be futile, once again aligning the substantive law with the procedural requirements. In our next episode, we're going to explore discovery. And that's a critical and, as I mentioned, expensive phase where parties gather evidence to prove their case. And we'll talk about how that's specific in the instances of shareholder litigation. But until then, this is Professor Seth C. Oranburg, and this has been Organized.